viewers. This is episode 7 of the Slarskey LLC video series on litigation finance and related asset classes. In this series, we discuss hot topics in the emerging area of litigation funding. Today's episode focuses on disputes involving litigation finance. We're lucky today to have two litigators join us as guests. From my firm, David Slarskey, and down in Washington, D.C., Derek Ho from Kellogg Hansen. I'm Evan Freed. I'm a partner at Slarskey LLC. We are a New York-based litigation boutique. We deal with a variety of financial frauds and disputes involving lawyers generally. A number of our cases currently and in the past have involved litigation finance and disputes emanating from that area. So if we could just go around the horn and our guests today give a brief introduction on themselves. Derek, do you want to start?
Sure. Thank you, Evan, and thanks to those of you who are watching. My name is Derek Ho. As Evan mentioned, I'm a partner at the Washington law firm of Kellogg Hansen. I've been there for about 20 years. We are I guess you could say, a litigation boutique firm. We do large stakes commercial litigation on both sides of the V, plaintiff side and defense side. And we do a lot of work in the litigation funding space, representing litigation funders, doing diligence projects for litigation funders, and litigating cases that are funded by funders. So I look forward to the conversation with you, Evan, and with David.
I'm David Slarskey. I first encountered litigation funding when I was counsel at Patterson Belknap, probably at this point, almost 15 years ago or so, as the commercial litigation funders were starting to make outreach into some of the bigger, more traditional firms, and developed a greater familiarity working with Evan on these issues as we joined forces back in 2016 to think about where there were gaps in the market and how maybe we might be able to develop some litigation funding interests. Evan didn't mention, but we also have a small funding vehicle where we invest in primarily small, six-figure investments for costs and funding in law firms. So we've been kicking around these issues for almost 10 years at this point, litigating some of them, funding some of them, never litigating the ones that we funded or funding the ones that we litigate for ethical reasons that we could talk about. But looking forward to talking about some of these issues.
Good. Well, let's start at ground zero and go back in the Wayback Machine. Derek, you were involved in kind of the seminal litigation finance dispute, one of the early disputes in the space, the Chevron Burford issue. You want to talk a little bit about that and what your involvement was with that particular dispute?
Sure. The Chevron Ecuador litigation, I think, is well known, but in a nutshell, there were Ecuadorian plaintiffs that sued Chevron over environmental contamination from a project that Chevron was pursuing in that country. And they obtained a massive, multi-billion-dollar judgment from Ecuadorian courts that they then sought to enforce in courts across the world, including here in the United States. And it eventually was revealed that the Ecuadorian judgment was, to put it bluntly, procured by fraud. And so once that became revealed, Chevron went on the attack against the plaintiffs and those that were supporting the plaintiffs. In that particular instance, Burford Capital, which I have represented and continue to represent, provided some funding to the law firm Patton Boggs, which had been involved on the plaintiff side. And so there was litigation involving Chevron and Burford, in which Chevron basically accused Burford of being complicit in the fraud on the plaintiff side, except that in reality, Burford wasn't complicit. Burford knew nothing about the fraud on the Ecuadorian courts, and Burford ultimately persuaded Chevron that it had done the right thing, that once it became aware of the fraud, it essentially disclaimed its investment in the case. And ultimately, Burford and Chevron entered into a public settlement in which Burford gave up any right to any proceeds in the Ecuadorian litigation, and Chevron essentially gave Burford a pat on the back and said that it had acted responsibly. This came at a time early on in the kind of life of litigation funding, and so it was a big deal in the industry because there was some potential prospect that it would sort of give the industry a black eye right off the bat. But we represented Burford, and I think that at the end of the day, you know, now looking back at the case almost 10 years hence, more than 10 years hence, it really didn't have that effect on the industry. And that's because that case is really quite anomalous. You know, there's probably no other case like it in the history of litigation, you know, in the relatively short history of litigation funding. Maybe there never will be. But while the timing wasn't great for an industry that was just getting off the ground, I don't think it really came to represent, you know, a long-term problem for the industry. When I think of disputes about litigation funding, I think of more mundane disputes that arose right off the bat when litigation funding industry sort of took off. And those were disputes really about two types of problems. One is existential. Is litigation funding lawful or not? And there were arguments made at the outset of the industry, there continue to be made to some degree now, that litigation funding in essence is unlawful under the law of various states because it constitutes champerty. Mm-hmm. And we were involved in some of those early battles, and they largely, you know, and we've largely prevailed on that issue, although the fight continues on. And then the second kind of dispute was maybe not quite existential, but significant, and that is whether defendants can obtain discovery of the information that's exchanged between a litigation funder and the plaintiff. As you can imagine, a funder requires a significant amount of, you know, potentially sensitive information in order to decide whether or not to make an investment. And so, again, early on, when defendants got wind of the notion that there were funders out there that were providing capital to plaintiffs, they served subpoenas on the funder and then discovery requests on the plaintiff, essentially asking for all the information that had been shared. And you can imagine that if that tactic had succeeded, it would have really made it very difficult for litigation funders to invest in cases, because it would have meant that a plaintiff would have to reveal essentially all of its litigation secrets, its work product, in order to get a funder to invest. Fortunately, we were able to develop what is now, I think, a very solid line of cases that holds that those kinds of communications are protected by either the attorney work product doctrine and or the attorney-client privilege. And so while we continue to fight those fights, again, in various courts across the country, again, by and large, I think the industry has prevailed in those kinds of disputes.
What do you think about that, Derek? I mean, take half a step back. I mean, set aside the analysis of the diligence that the lawyers are performing on behalf of the funders, which is obviously privileged or should be privileged as attorney-client communications, if not work product. I mean, why do you think the factual information should be privileged? I mean, if you have either the funder is inside and controlling the litigation or has rights to directly influence the outcome of the litigation, in which case I could see, you know, in which case maybe you're running closer to the champerty rules or closer to controlling the litigation. or the funder is an outside party that's reviewing facts related to the evidence that's at issue in the case. I mean, why should the factual information that's shared be held to be privileged?
It's a great question, David. I think that if you're talking about brute facts, facts about the world or facts about the plaintiff's business that don't involve any attorney advice or attorney analysis, those brute facts are not privileged by virtue of the fact that they are communicated by the plaintiff to the funder. But again, generalizing somewhat, courts have still found that it's not appropriate to seek discovery of those facts by asking for communications between the plaintiff and the funder, for the more mundane reason maybe that those facts are already in the possession of the plaintiff. And so, the defendant can certainly seek that information from the plaintiff, but there's really no need to obtain that kind of information from the funder unless there's some particular showing that the funder has unique access to those facts, which ordinarily wouldn't be the case. So I agree with you, the factual part really isn't protected from disclosure so much as it's just not proportionate and it's overly burdensome to be asking a third-party funder for that information.
But what about the fact that they shared it with the funder? You could imagine an entrepreneurial litigator making arguments about consciousness of guilt, about understanding of materiality, issues of intent, issues of understanding, based on the fact that certain facts were shared with a funder under those circumstances. I mean, it's a little bit of a nuanced point, but I take your point that the brute facts are already in the possession of the plaintiff. There's another way to pursue that fact. But do you think that a party should be permitted to prove to a court, hey, this party, when it's trying to assess the riskiness of its claim, or when it's trying to determine the likelihood of success on its claim, is showing these particular facts to the person who it's asking to make that decision?
I think ordinarily, I would say that actually the sort of selection of those facts is what is protected. In other words, if you envision that I, as an attorney, sit down and I compile, the documents that I think are most important about the case, so that I can then share them with the litigation funder. That compilation of documents reflects my mental impressions. And so it's precisely because I've selected those documents that the set of documents becomes privileged. Now, the work product doctrine can be overcome. If it's mental impressions, it's very, very difficult to overcome. If it's what's called ordinary work product, it still requires a showing of substantial need. But in theory, the defendant could make the argument that you were advancing, which is there's some very important reason that I need to know which documents Derek selected and why, because that selection is of paramount importance in the litigation. I would say that argument is rarely made, because I think it rarely could be made with a straight face in most ordinary.
You haven't seen me argue before, Derek. I can make an argument with a straight face.
I have a slightly different spin on the same question for both of you guys. One of the hot topics that I'm observing right now is whether the existence of litigation finance is something that ought to be disclosed to the side. And you see it manifest in a couple of areas. There was an order in the opioid litigation, and that was meant to bring to light that some of these law firms were backed by litigation finance. There's a local rule in New Jersey. I actually filed a case in New Jersey a few weeks ago, and our local counsel reminded me that we had to disclose the existence or non-existence of litigation finance. And just this week, there was a federal bill introduced that would be that would require in federal cases disclosure of the existence or non-existence of litigation finance. I mean, there is some rationale to this, right? When you file a case in federal court or in New York State court, the defendant has to disclose their insurance policy. So isn't this just the inverse of that? Where do you guys stand on that particular position?
I'm happy to go first, or David, you want to go first?
Yeah, go for it.
Okay.
No, go ahead.
Yeah. So I've said this before in response to these kinds of proposals. And to be clear, I'm giving you my own personal opinion throughout this podcast, but my own personal opinion is that the disclosure itself is not the heart of the problem. The heart of the problem is that the disclosure becomes the basis for defendants to use various tactics to try to increase the burden on litigation funding, and in particular to pursue the kinds of discovery that we were just talking about. So step one in the defendant's playbook is obtain the identity of the litigation funder. And if they stopped at step one, I probably wouldn't have as big of a problem with it. But then they move on to step two, which is serve subpoenas on the litigation funders for all the documents exchanged with the plaintiff. Now, as I said, the case law is, overwhelmingly in favor of protecting those kinds of documents. But merely by signing a Rule 45 subpoena, you can impose lots of litigation costs on the funder and the plaintiff. They've got to object and respond to the subpoena. They've potentially got to move to quash. They've got to review the documents to see what they have. They've got to potentially prepare a privilege log. We're talking tens of thousands of dollars of litigation costs that can be imposed just by signing that Rule 45 subpoena. And so I think if disclosure of the identity of the funder were paired with bright line protections against those kinds of burdensome discovery and other tactics, that might be a sensible policy. But if it's just disclosure and no protection, then I think it's just a mechanism by which defendants can effectively impose like a financial tax on litigation funding for no good reason.
I mean, I agree with that 100%, and would add to it. That's a problem throughout the system and throughout the process. And the longer you do this, and the more different ways you try to litigate disputes with different adversaries, the more you realize how easy it is to drive up costs, and how easy it is to delay resolution, and how easy it is to sign those subpoenas, issue those demands, and act in a way that is arguably unethical because it is intended to drive up costs and delay the resolution of the dispute. So I agree with you. I think that's an endemic problem to our to our litigation system, unfortunately. I'd also say that the comparison to insurance is interesting because insurance is highly regulated. And as you were talking, Derek, I was thinking through the questions we were just talking about, well, is it important that these particular facts were shared with this funder under these circumstances? What does that tell us about the underlying claim? What does discovery from a funder, what can it tell us about the underlying claim, if anything, and when? And the insurance industry is well regulated, and we all sort of understand what an insurance policy is, what an underwriter does. It's sort of difficult to imagine. I don't do a ton of insurance litigation, but I imagine that people don't typically go to insurance underwriters and try to subpoena the underwriting file to understand the damages in a catastrophic risk situation or a catastrophic failure situation. But it's highly regulated, and it's a well understood product. Here, the iterations of litigation funding, the various ways in which funders relate to parties, relate to lawyers, how the funding agreements come to be, what the arrangements are. I do wonder about it sometimes, and I wonder whether the funding industry couldn't benefit from some more standardization, that would make these relationships more predictable, so that the courts could feel more comfortable in setting down some of those bright line standards, and so that the standards around these agreements would develop in a more systematic fashion. Because as we see it, I mean, they're the Burfords of the world, but there's also a whole kind of shadow market of litigation funding, that is really unregulated and kind of the Wild West.
It's a really good observation, I think, David, because I mean, of course, whether you're pro-regulation or against it will depend on what the regulations are. But just thinking about what the legal frameworks are that exist today, they're really not kind of designed for this purpose. And more than that, I think as someone who litigates about these issues a lot, there's a lot of kind of conceptual confusion about the various bodies of law that are sometimes said to kind of regulate the litigation funding industry. So last episode, you had Tony Seebach on, and one body of law that some people who are trying to limit litigation funding impose is the rules of professional responsibility. So I have heard arguments made and opinions offered that, for example, a litigation funder cannot, have any involvement in a plaintiff's decision whether to settle a case, invoking the rules of professional responsibility. That's, in my mind, conceptually flawed. And the reason is because the rules of professional responsibility regulate the relationship between the attorney and the client, in this case, the plaintiff. And when they talk about the client having settlement authority, they are talking about vis-a-vis the lawyer. In other words, the lawyer can't take away the client's settlement authority. But the rules of professional responsibility just don't regulate the relationship between the client, plaintiff, and a litigation funder. That's just not at all what those rules were designed to do. So there's just this category mistake that's often made, that when people argue that the rules of professional responsibility have something to say about the relationship between the plaintiff and the litigation funder. So there's all these different rules and frameworks out there, and people don't really think clearly about what those rules and frameworks actually regulate, and they just try to employ them all in order to try to make arguments about what litigation funding limits ought to be.
Sure. I mean, look, I tend to agree with that. It's a little bit of apples and potatoes. And my own personal prediction is that we will see, more clarity come from the jurisprudence, from the local rules. Perhaps there'll be some federal legislation speaking to these, certainly as the market develops. And, as long as they're within the metes and bounds of what the industry is meant to do, and how it can do it safely, I'm not necessarily opposed to it. Shifting bases a little bit, Dave, I know you've been looking into, and we have a firm have done some of these cases as well, a whole separate body of the regulators, and we're talking about the investor disputes, the disputes really between the investors and either and the funder, or the funder and the regulators in certain situations. And there's been a bit of a flurry of these recently. Do you want to talk about some of those issues?
Sure. So I think for consumers of litigation funding, they need to understand how the market is structured, and what's behind the funders that they're dealing with, because it's like anything else. You're going to see a surface, you're going to see a product that's presented to you, but one of the consequences of a lack of regulation or lack of clarity in regulation is that what you're seeing is oftentimes not clear, right? So if you go to Burford, you're dealing with a publicly traded company that has a well-regulated and well-established body of law around it, and and information that's disclosed about its finances and about its business and everything like that. But there's also a litigation funding market out there for consumers, and I think this is really where regulation probably has the most likelihood of being helpful to the market, because there are a lot of kind of private label, almost fundless or of questionable financial stability funders out there holding themselves out as litigation funders and offering advances, offering case funding, and they are the front for pulling in investor money or calling down capital on a case by case basis, on a tranche by tranche basis, or on a pool by pool basis. But if you are a consumer and you're accessing the litigation funding market through one of these less regulated entities, you are subject to the irregularity of whatever's going on in the background. So whatever representations that funder is making to collect capital or pool capital, or whatever it's telling its investment sources, whatever it's doing in the background can impact the availability of that funding to support your case. So you need to be sophisticated and smart to ask those questions about where is the capital coming from? Who are the sources of capital? What are your relationships like on the backside of this outfit? And we've seen all kinds of things, everything from, because there's so little regulation and disclosure, and because these are very bespoke financial products, basically, there's a lot of room and opportunity for call it creative bookkeeping, call it fraud, call it Ponzi scheming, selling cases multiple times to investors. There's a whole kind of playbook of ways that unscrupulous litigation funders can kind of roll their problems forward or conceal their problems forward. And it puts the consumer at risk. I mean, that is an issue. And if there is an area where greater regulation and transparency maybe does play a role, I could see that as an area, because it's not obvious to consumers who they're dealing with sometimes, or what the real source of the capital is. This isn't something you're going to worry about with a publicly traded, or you're going to worry about to a much less degree with a publicly traded or highly regulated entity. But particularly with like these private label outfits that are out there kind of shaking trees, there's real room there for wrongdoing and for confusion.
I mean, the big thing that I've kind of highlighted or noticed is that there's no standards of reporting to evaluate litigation assets or law firm loans or whatever they are. They are often they hinge on speculative litigation, which might go belly up or might hit at any given moment. And there's always going to be information asymmetry. There's going to be information asymmetry between the law firm and between the client and the law firm, between the law firm and the funder, between the funder and the institutional investors or family offices, whoever it may be that is ultimately backing that funder. And that that information asymmetry, combined with the appeal of too good to be true returns, does create a tremendous opportunity for
no recourse, right? No recourse is ultimately probably is the get out of jail free card, right? Because when at the end of the day, if you lose, you don't have to pay it back. There's the opportunity for a real perverse incentive to be established. I mean, you have I've used it so many times at this point, but you have the producer's problem, right? Where somebody's better off losing a case, right? Because then you don't have to go pay off the funders, you don't have to pay off the client. Like there is the possibility for perverse incentives when there's no recourse, because just by the structure of the market. It's interesting. I mean, when it's used properly and transparently and ethically and in a reliable fashion, litigation funding is a an incredibly useful tool for clients who otherwise would often be stuck. But there is a dark side of it as well, because it can create a lot of problems for people who get involved with unethical and less transparent parties.
So David, are you seeing litigation or other disputes arising between the funds and their investors over these kinds of issues?
Oh yeah, I mean, we have a few that we've touched. Um, they're being litigated now, but we've definitely seen kind of what I would call these sort of like private label funders, who are engaged in unscrupulous bookkeeping, recutting deals, cutting deals twice, recirculating cash, restructuring the investments because there's no standardization. Um, and I think there's also a little bit of like elitism associated with the fact that it touches the legal market, right? People don't want to ask too many questions. The investors maybe feel like they don't have the understanding or sophistication to ask the right questions because lawyers are doing that, because this is all going on in the courts. It must be kosher, or it must be clean. We've seen a number of them. I mean, Evan and I have litigated several of them over the last few years where it's just unscrupulous practices behind. I mean, people have gone to jail over selling selling cases multiple times to multiple investors, and all of a sudden, when the checks come in, it's the producers. They'd be a lot better off if the cases all failed because they've oversold the buckets. It's an interesting area. I mean, it touches on legal ethics because oftentimes lawyers are the ones that know or should know this is going on, right? They have the information to see what's going on and to understand that there's an ongoing fraud. Sometimes they don't come forward, or sometimes they rely on kind of the client relationship and kind of hide behind their professional role. But it touches on a lot of interesting issues here.
So we're coming. We're just about up with time. I have one final question for each of you. I'll start with you, Dave. What are your predictions for additional government action, whether it be by the SEC, DOJ, concerning these types of frauds or efforts to increase transparency and standardize reporting from litigation funders?
Continued gridlock, inability to work together in adopting appropriate policies, and chaos on January of 2025. How's that? No, um, I don't know. I mean, I think that things will develop slowly. I think we will continue to see different courts in different parts of the country treat these agreements and the arrangements somewhat differently. Ideally, we'll see different states experiment with different kinds of disclosure rules, as you were saying, local rule disclosures, and see what happens. And I think it'll be slow. And my prediction is that it's a pretty small market. That is the other thing. It's like, for all the talk, for all the marketing that goes into it, and for all the clubbiness amongst the litigation funding community, it's a pretty small market. And so I don't think that we're going to see like huge huge leaps and bounds changes. I think it'll continue to develop slowly. And I think that what we've been talking about will ultimately prevail, in that, the recognition that some disclosure is appropriate, some information is appropriate, but that at the end of the day, it's just another aspect of litigation, and it doesn't need to become the focal point of the litigation itself.
Got it. And Derek, on your side, we've talked about a lot today. We've talked about champerty, discovery of litigation funders that disclose whether litigation finance arrangements must be disclosed to the court in camera or otherwise. What do you have your eye on as one of the major issues that should be fleshed out in the next few years?
Yeah, my thoughts are in line with David's, which is that by and large, there have been some legislative proposals that have surfaced from now and again. I think those are largely solutions in search of a problem, and they haven't really gone anywhere. There is a little bit of a new twist in the current bill and the current sort of talking points from those who are antagonistic to the industry, which is the notion that there's foreign money influencing American litigation. To me, that's a bogeyman, but, in this political environment, it's hard to say whether that gets any traction or sufficient traction to motivate people to, enact some kind of legislation or regulation.
Xenophobia comes to litigation funding. It's unbelievable. This is 2024 we're living in.
Yeah. Grasping at straws, I would say.
Well, guys, thank you both for joining today. This has been episode 7 of the Slarskey video series on litigation finance. Thank you both for joining.
Thanks, Evan.
Thank you.
Thank you, Derek.